We come to the last part here, and that is, what is the result? What has been the response? Are there critics to its actions? Or has that been accepted wholeheartedly, warmly, with great appreciation? It's actually a mixed bag. It has been a mixed bag for a variety of reasons. And that's what we are going to examine now. And then where exactly it stands is what we are going to examine. If we just look at the host of responses and reactions from various quarters that matter, it looks as though that the very success of NGT in championing the environmental cause appears to have been its own undoing. The indications for that are given in narration of a few of those for you to comprehend, understand, and draw conclusions. One, its decisions are being challenged in various high courts under Article 226. You must know a little bit of the Constitution here. The law says, under the NGT Act, any order or decision made by NGT, only appeal will lie to the Supreme Court. But under the Constitution, there is a power vested in the high courts, just like in the Supreme Court, to take up any issue, any case which has something or the other to do with public interest, human rights, fundamental rights, and entertain them, notwithstanding anything that is there in any law to that effect. So, the jurisdiction of high courts are never outstepped. Higher judiciary, as the sentinels and custodians and the guardians of constitutional rights, to issue writs to enforce them, is never compromised. There cannot be a law which will take away their powers. And so, many a time, very interestingly, governments and corporate entities against whom orders are issued by NGT have been challenged either as violation of a fundamental right or something against public interest, something which is not going to really serve the purpose of the public under Article 226. And even the high courts have entertained such petitions. And here, a kind of a psychological game is played by those petitioners who found it very inconvenient to digest decisions given by NGT by coming up with this kind of an argument that the High Court's superiority over NGT, actually this was never an issue, but this was actually touted as pitting High Courts against NGT. High Court is a constitutional body, while NGT is only a statutory body. And so, you cannot say that NGT decisions, NGT orders and instructions can never be challenged in the High Court. When the law was made in 2010, when it said that the appeals from the orders of NGT would lie with the Supreme Court, it never said anything about this kind of a thing. By entertaining such petitions, the High Courts have fueled such a debate in very well informed circles that NGT might have exceeded its jurisdiction by taking on too many things that it was not meant to deal with. There may be an element of truth in it, or it may even be exaggerated. Both are possible. These need have to be debated and these need have to be sorted out, not in the manner in which it is being attempted here, as to really decry one institution in order to ensure that business as usual would continue. Unfortunately, the end result has been that. But it is no denying that there is some truth in such a critic. Like for example, NGT began entertaining proceedings suo motu, that is on its own accord, even without any complaint being filed, or even when complaints on certain issues are filed, it started issuing orders on subjects which were not directly related to the issue on hand. Actually, suo motu powers are exclusively with the High Courts and Supreme Court. Under this law, suo motu powers is not contemplated, and it's more like a constitutional power vested in the higher judiciary in the form of High Courts and Supreme Court. But NGT started entertaining such actions. I'm just giving you an example. That's the case of KJ Pavlos, and this was in 2013. What did NGT do? Issued directions to the State Pollution Control Board for prevention of pollution of the river Periyar by industries and to take appropriate action in case of violation, including closure of units after following due process of law. This was not an issue on hand. On its own, the NGT took it up, and this actually created a lot of ill will. Second, how did the bureaucracy react to the actions of NGT? At the higher levels of administration, especially the chief secretaries and secretaries, when they were repeatedly summoned, reprimanded, questioned, ordered, they did not and they could not take kindly to some of its actions. They were summoned, they were reprimanded for poor record, especially on waste management. Even fines were imposed on state governments, and this made the entire bureaucracy to be viewed in poor light. And especially when the higher echelons of the ladder in bureaucracy are taken to task, you cannot expect them to take things lightly or lying down. And the backlash was imminent, and that was happening. And you do see either non cooperation or some actions to clip the wings of NGT. I'll come to that a little later. The other major problem with NGT was absence of a formula based mechanism in determining the compensation by the tribunal. There are instances, as we have seen earlier, of imposing pay 25 crores, pay 100 crores, pay 500 crores, that kind of a thing done by the tribunal. And what is the criteria? They invariably refer to the principle of polluter pays. Principle is only a principle, but you need an operative tool of working the principle. And what is the tool? The tool is number one, a formula. How do you calculate? How do you calculate the environmental damage? How do you calculate the environmental costs? How do you calculate the repair costs? You need to have a kind of a checklist on the basis of which you will determine the quantum of payments that are to be made for redressal, recovery, restoration, retrieval, or positive action. But the amounts fixed by NGT do not have that kind of a rational basis or a clearly evolved criteria, and it is but natural that there was criticism that they are arbitrary. As a matter of fact, one may agree that the orders passed by them may appeal to the heart, but we are talking of law. We are talking of money. We are talking of investments. We are referring to something which is in economics. We are talking of something which need have to be related to each other, the cause and effect and the impact. And so the thinking mind refuses to recognize them in the absence of a clear set parameters for such a calculation. Take the example of Manoj Mishra versus Union of India. Clean and rejuvenate Yamuna River. That is what the NGT issued directions to the civil and municipal authorities. And what was the direction? Collect so much of money on every household as environment compensation fee as part of the property or house tax. This is a done thing everywhere, but how do you really calculate that? Follow polluter pays, that's what it said, without actually laying down the criteria. In Krishan Kant Singh versus National Ganga River Basin Authority, what did NGT do? It directed the defaulting industrial unit to pay a compensation of 5 crores to the State Pollution Control Board. Once again, basis polluter pays. Or it enabled the authority to undertake remedial activities to ensure river conservation. And in Patel versus Union of India, a 2014 order, it directed environmental compensation of 10 lakhs. Look at the language used, environmental compensation. What does that mean? How do you calculate that? 10 lakhs to be paid to the aggrieved farmers of Vapi in Gujarat due to hazardous waste pollution. Pollution has occurred, nobody is denying it. How do you calculate? Whether it is 10 lakhs or 10 crores, please give us the rational basis upon which you collect the cause and effect and quantify the amount of money to be paid. Somehow, that was not done. A very cavalier way in which it was done, and this is something that has actually raised many an eyebrow. On a number of occasions, the decisions given by NGT are not fully complied with or implemented by the stakeholders of the government on the plea of non-feasibility of giving effect to them within the time frame fixed by it. We could have done it, but you have fixed too short a period of time, no time to think, deliberate, and act upon. Sorry, we cannot do, and we can only do this much. The decisions are also criticized and even challenged because the kind of repercussions they will have on economic growth and development. By whom? Even by government departments who should act, and of course by the corporate entities. Oh, this is an ideal situation that you are coming up with. This may work in Germany, it may work in United States, but look at Indian conditions, and in Indian conditions to work it will be economically ruinous. And when once the issue of economy comes, when once the issue of development comes, the political leadership would suddenly wake up and will start criticizing the orders and will put hurdles for the working of any of the decisions given by NGT. And that's what actually happened. All this had its backlash from the administration. The administration started acting in such a manner where it would hurt badly, hurt in such a manner that NGT would be paralyzed and will not be able to function properly because it is giving too many headaches to so many people all the while, and it started putting hurdles in the working of NGT. How could it do? It could do this in a number of ways, but it took advantage of what is not provided under this law and over which NGT started acting upon. Like, for example, if we just look at the list of the laws that are there, which come within the pale and purview of NGT, Wildlife Protection Act is kept out. But invariably, many of the orders and actions of NGT have a bearing upon wildlife law. And so, challenges have come to high courts that look, this is an issue, high courts are better and competent to deal with, and NGT should not, they have actually transgressed their limits. So please entertain petitions. And courts have entertained petitions on the actions of NGT as being beyond their capacity, and they have given different orders. And this has become a bit of a problem because if you only deal with forest and forest rights, how do you really deal with them without bringing in the other related laws within the purview of this authority? Either you remove them, all of them, or you include every one of them. Some or the other, the law is not helpful. When it was planned and visualized in 2010, in picking some laws, putting them within the purview of NGT, and leaving out some laws which are very closely related to them out of its purview. So there is a bit of a manufacturing defect in the law as to hinder the effective working of this tribunal and also helping administration and corporate entities to take advantage in this gap in the law. But much more so is what the Ministry of Environment and Forest has been able to do, or has not been able to do, or did not do. On a number of occasions, in no subtle manner, it hinted the tribunal, look, there is a lot of resentment. Please limit your jurisdiction. Please confine yourself to a recommendatory role, especially on matters concerning environmental clearances. We have looked into all these issues. We have given clearances. Please give us recommendations. Don't give instructions to us. Don't issue orders upon us. But you know that in a number of cases, and I have just referred in this slide, the case of Prafulla Samantrai versus Union of India, the POSCO case. The tribunal has rejected all these pleas of ministry. It had asked the Environment Ministry to review the clearance process, especially when the local community have refused to give consent to the project. How could you overlook that and take decisions and clear projects? Because it is violative of some of the laws like Forest Rights Act. So it is very understandable that because of this, either on account of an overreach, over enthusiasm, or whatever, there has been lethal, paralyzing reaction affecting the working of NGT. The ministry, its actions have been almost crippling. Like since 2018, a number of vacancies have occurred in NGT, and the ministry has not made appointments till now. So, what is the result? The result is its work has been hampered, and the repeated demands, not just in NGT, not through emissaries sent by NGT to the government that fill in these vacancies, even these issues are raised in high courts and Supreme Court, but it has borne little fruit. The real fear that one would have is that this body may meet the same fate as that of NEAA, National Environment Appellate Authority. You already know, as we have discussed, how it worked between 1997 to 2000, the National Environment Appellate Authority. But from 2000 onwards, how its work was crippled. The same is the trajectory of development taking place with regard to NGT. As on balance, it can be asserted that the working of NGT, whatever one may argue, required a little bit more professionalized by way of organization, procedures, and clear and reasoned decisions, like we expect. That in the case of administration, when they issue orders, the orders should be speaking. They are called as speaking orders. That when you issue an order, the reasons for why you have come up with this kind of an order should be an integral aspect of the order, so that people would know why such orders are issued, why such directions are issued. Some or the other, in recent times, or even right from the very beginning, as we have seen in many cases, this has not happened. It's just issuing orders, giving instructions, do as I say. That won't work. So maybe a little bit more tact, a little bit more diplomacy perhaps would have helped the NGT to sail over the troubled waters that it has gotten into. But all said and done, in conclusion, it must be stated that whatever there are weaknesses and shortcomings in NGT, this glorious experiment in environment justice dispensation, unparalleled anywhere in the world, should not be made to die, because NGT remains the only and the final hope for the protection of environment in India.